Good morning to everybody. Welcome to the class of the remedial of the law taught for the people, those who are going to sit in this month, 27th, 2021 September. Yes. Now you tell me, Ramesh, whether you could hear me or not. Could you see my screen or not? Yes. Unmute and give me the answer. Yes. Unmute and give me the answer whether you could see my screen or not. Ramesh, unmute and speak. At least say namaste. Yes. At least you say namaste. Okay. Read what I posted on the screen. Okay, it doesn't matter. See, I will read it to you. World Rose Day is annually celebrated in September 22 in dedication to the welfare of the cancer patients. On this day, people around the world work towards bringing the cheers and hopes into the lives of all those people who have been affected by cancer. More importantly, it seeks to remind patients and their caregivers they are not alone in this battle against the deadly disease. The theme of the World Rose Day 2021 has not been announced yet. Last year, 2020, theme was changing the way we look at a cancer. The World Rose Day theme focuses on the spreading the awareness about the causes and the prevention of the cancer. So today is 22nd September 2021, World Rose Day. So now let us come to our point of studies. And in the last class, we discussed earlier the distinction between the gross negligence and the general negligence. Now we will see the types of the negligence claims. Let us see the negligence refers to a variety of the injury cases. And depending upon the where you live and you state, may have a certain criteria demonstrating the constitute the acts of the carelessness. Your carelessness will be in many fields, like automobile collision, there is a carelessness, and the medical malpractice, there is a carelessness, workplace accident, there is a carelessness, defective product, there is a carelessness, premises liability, there is a carelessness, and the elder abuse or neglect also there will be a carelessness. In the one sense, in another sense, carelessness or the negligence is the species, and the different offenses in the torts are called species. So that is the whole idea behind it. Yes. Yes, Ramesh. Do you want to ask anything or shall I proceed? Shall I proceed? Say yes. Okay. Essential of the negligence. What are the essential things should be there for the negligence? To commit the tort of the negligence, I repeat, to commit the tort of the negligence, there are the primarily six main essentials that are required. An act will be categorized as negligence only if all the conditions are satisfied. Namely, and here the conditions are like this. Number one, duty of care. Number two, and you can say that the duty must be towards the plaintiff. Then we can score on number three, breach of the duty to take care. Then number four, I'm scoring actual cause or cause in effect. Then number five, proximate cause. Then the number six, the last one is consequential harm to the plaintiff. These are the six elements should be there. But in some of the books that you will find only the four elements, which will give the broad aspect of the negligence. But precisely when you want to analyze it, we can make it a six. Now let us see what is the number one. That is the duty of the care. The duty of the care on whom? Is it the defendant or a plaintiff? The answer is it should be on the defendant. It is one of the essential conditions of the negligence in order to make the person liable. It means that every person shows a duty of care to another person's while performing an act. Although this duty exists in all acts, but in negligence, but the duty is legal in nature and can't be illegal and unlawful, and also can't be moral or ethical or religious nature. So the duty should be legal and it can't be illegal and it cannot be unlawful and they should not be immoral and it should not be the ethical, it should not be the religious nature, but it should be the legal in nature. Let us see the one of the case law. There is a Grand versus Australian Knitting Mills Limited. There is a 1935 case law. That is the appellate court, and 85, the page number. The plaintiff purchased the two sets of the woolen underwear from a retailer and contracted a skin disease by the wearing an underwear. The undergarments, the two woolen undergarments, the person, the plaintiff purchased, after wearing it, that he developed the itching sensation in the groins. The woolen underwears contain an excess of the sulfates, which the manufacturers negligently failed to remove while washing them. The manufacturer were held liable to, as they failed to perform the duty to take care, because there is more sulfate would be there in the undergarment which did not wash by the manufacturer. With that sulfate, there is a itching sensation would be there in the groins, and hence the manufacturer would be held liable, because the duty of care is not taken. That is nothing but washing in a such a manner where the sulfates will be comes out of these undergarments. That is the case law. Now, can you read the what is the next case law, Ramesh? In the case of, which is there on the screen, is it possible to you unmute and read? Oh, the weakness, there is a weak signals are there. Okay, doesn't matter. I will read it. The Stansbella versus Trauma, that is a case law where a decorator was engaged to carry out the decoration in a house. Okay. Of course, light decoration is there, paper decoration is there, painting decoration is there, and many other type of the decoration in the events of the festivals or marriage or special occasions. And soon after, the decorator left the house without locking the doors. So this decorator, what he did it after decoration or middle of it, without locking the doors and without informing the anyone, and he left over there. But meanwhile, during his absence, a thief entered the house and stole some property, the value of which the owner of the house claimed from the decorator. Because he failed to lock the door, who? Decorator. And meanwhile, a thief entered the house and stole some of the property. That is the open invitation to the thief when the doors are open. So it was held that the decorator was held liable as he was negligent in having a house or the house open and failed to lock the house. Is it clear? So there is a duty of care would be there on the decorator should have to lock it when he was going out. In the same manner, there are cases Hans versus Barrington London Borough Council and the Capro Industry PLC versus Dickman. It is the 1999 case law, and they restricted the definition of the little by introducing proximity and fairness. Another, of course, the another element they introduced, the proximity would be there, very nearness would be there, and the forcibility would be there, and the fairness would be there when we are enforcing such a right. Okay. Number two, the duty must be towards the plaintiff. The duty must be towards the plaintiff. By the whom? By the defendant. A duty arises when the law recognizes the relationship between the defendant and the plaintiff and requires the defendant to act in a certain manner towards the plaintiff. And it is not sufficient that the defendant owed a duty of care towards the plaintiff, but it must also be established, which is usually determined by the judges. So now the question of what the duty of the care would be there on the plaintiff by the defendant. Let us see the classical case law is the Boril versus Young. There is a 1943 case law. The plaintiff, who was a fishwife, got down from a tram car. I don't know whether you know the tram. The trams will be generally, I think it's the electric. If not the electric, okay, diesel also. But it moves on the rail. And we'll see the trams in the Calcutta, because that is the East India Company where the British had come. They made the trams over there on the roads. Of course, in other places, I don't think that I did see the tram. But the trams are there in the Turkey also, because I saw in the Istanbul. The trams are there in Turkey. That is the capital is Istanbul. Okay, let us come to the point. From tram car, while she was being helped in the putting her basket on her back, and a motorcyclist, after passing the tram, collided with the motor car at a distance of 15 yards, which one of the other side of the tram. So now the question comes over there. She heard the scream. that an accident happened between either motorcyclist with any other tram collided over there. Yes, it's a tram because it is clearly mentioned the motorcyclist after passing the tram collided with the motor car. Of course, passing of the tram collided with the motor car. That means the accident between the motorcyclist and the motor car when the tram passed over there. The motorcyclist died instantly, and the plaintiff could not witness the accident or the dead body since the tram was standing between her and the place where the accident occurred. She had only heard the sound of the collision, and hence the body has been removed from the place of the accident. But she saw the pool of blood on the road. She visited the place and saw some of the blood which was left on the road. That's why I told you, pool of the blood on the road. And as a reaction to this incident, she suffered a nervous shock and gave birth to a stillborn child of 8 months. At the time, she was pregnant, and by looking at the pool of the blood on the ground where the accident happened, then she has given the birth because of the shock. The 18 months birth child, because of which she sued the representative of the deceased motorcyclist. Of course, when he has given the birth to the still the child of the 8 months, at that instance, of course, the child is stillborn child to as far as possible. Yes, it is a true fact also. So the deceased motorcycle, she filed a case because of her. She has given the premature delivery and of course stillborn child, and it was held that the deceased had no duty of care towards the litigant, and therefore he should not claim any damages from the deceased representatives. At that instant, there is no duty on the plaintiff because it is she who went over there and saw the pool of the blood on the road, and she did not see directly the what is the accident. Moreover, she heard the scream also. She voluntarily came over there and she suffered over there, and hence there is no duty of care towards the plaintiff here by the defendant. So that is the same thing. The duty must be towards the plaintiff here. That there is no duty of care towards the plaintiff by the defendant. Hence, she should not succeed. She will not succeed. She could not succeed. She did not succeed. A person with a chicken heart, they are not supposed to go such a places. Even a person with a chicken heart, they should not see the horror and terror movies or ghost movies. If after seeing the ghost movies, and if a person got ill or become the mental shock, that means he could not get it because he should not supposed to see it when he doesn't have or she doesn't have such a dareness, such a lion heart. Okay. Let us see the another case like the Donovan versus Stevenson. This is a very classical case law of the 1932, which evolved the principle that we each have a duty of care to our neighbor and someone who would reasonably expect be affected by our acts or omissions. Either the act or the omission doesn't matter. There should be a duty of care towards the plaintiff should be there, and it was held that despite the no contract existed between the manufacturer the person suffering the damage and an action for the negligence could succeed. The reason is the plaintiff was successful in her claim that she was entitled to a duty of care, even though the defective goods, a bottle of ginger beer with a snail in it, was bought not by herself, by her friend. Doesn't matter. If anything which is consumable in nature should be worth enough to consume. If any other thing would be there which enters and make the putrefied and unworthy to consume over there, at that instance, the manufacturer would be held liable because if there is no break of the chain, uh, such a thing, then the manufacturer would be held liable, even though the consumer who may be. So this case law will give it party to the contract cannot only the sue it, even the party who are not contract to the party can also sue, and hence the privity of contract is no more applicable in the law of tort because consumer, the last person who is consumed it is the party over there. Until he consumes and suffer the injury, he will not be known to anybody, or she will not know to anybody. So that is even the privity is may not be there in the law of tort, but the privity is there in the contract. So that is another word that we can make it out. A person who is not in the contract can also file a suit because the drink was bought by somebody else, but somebody suffered over there. In that instance also, the manufacturer is held liable. Yes. Number three, breach of a duty to take care. So there should be a breach of a duty, and that duty to take care should be there. There is another is a legal duty, not a moral duty, not a ethical duty, not a religious duty. It is not enough for a plaintiff to prove that the defendant owed him a duty of care, but he must be established that the defendant breached his such duty to the plaintiff, or the defendant breaches such a duty by failing to exercise the reasonable care in fulfilling the duty. In other words, the breach of duty of care means that the person who has an existing duty of care could act wisely and not omit or commit any act which he has to do or not to do it, do as well. And tell in the case of the Bleak versus Birmingham Water Works Company, in simple terms, it means non-observance of the standard of care. And duty of care also in such a way, the standard of care should be applied over there. But in the Bleak versus Birmingham Water Works Company, they have taken the reasonable care over there, but still the wall burst over there because of the heavy cold at the time, the season, and the wall was burst. Even the wall is not made with the iron or the cast iron, it is generally made with the alloy, that is brass or the copper mixture. So that will the wall would be there. At that instant, the duty of care they have taken, but still it is happened. It is said to be the inevitable accident in one way, in another way. Let us see the another case of the Ramesh Kumar Nayak versus Union of India. The post authorities failed to maintain the compound wall for the post office in a good condition. For the collapses which the defendant sustained the injuries, it was held that the postal authorities were liable since that had a duty to maintain the post office premises, and due to their breach of the duty to do so, the collapse occurred. Hence, they were liable to pay compensation. Suppose the Union of India. Why the Union of India? Because it is a postal department belongs to the central government. That's why central government Union of India is sued over there, because they are supposed to take the duty of care to maintain the wall, because the wall is collapsed because of it is drenched in the water and later on collapsed it and more say repair also. And if they did not do so at that instant, Union of India is liable, because if any person like the Ramesh Kumar Naik or he himself or other person got injured because of the collapse of the wall. So that is the compensation will be paid over there. Then the another remarkable case that we will see that the municipal corporation versus of Delhi versus Subhagavanti. That is nothing but a clock tower case law in the Chandni Chowk in the New Delhi. So the very old clock tower is situated right in the middle of the crowded area of the Chandni Chowk suddenly collapsed there with the causing the death of the many people. The clock tower was 80 years old, although the normal lifespan of the clock tower should have been 40 to 45 years. The clock tower was under the control of the Municipal Corporation of Delhi, and they had a duty of care towards the citizens. By ignoring to repair the clock tower, they had breached the duty of care toward the public and were thereby liable. So that is the another case now. Again, the Municipal Corporation of Delhi versus Shushila Devi, a person passing by the road died because of fall of a branch of a tree. Here, the branch of a tree, which is controlled by the Municipal Corporation of Delhi. And here, the branch of a tree standing on the road on this head, the Municipal Corporation was held liable because they had to make the checkups every time to see any branches are going to collapse or break down, and they have to see it. They try to remove it, they have to cut it if such a hazardous thing would be there. Yeah. So a good case which illustrated the but for test opportunities concern Barnett versus Chelsea and Kensington HMC. This is another medical case. A casualty department doctor negligently sent a patient home. The patient died. However, the doctor was not found liable for the damages because the patient was suffering from a arsenic poisoning. Where is the dangerous poisoning? If you do also, you will die. If you doesn't do also, you will die. The death is imminent. The arsenic poisoning and would have died no matter the negligent doctor could have done. So when such a thing would be there, either you do it or you may not do it, the patient will die because the patient condition is in such a way, and hence no liability would be there on the doctor. Number four, actual cause or cause in fact. There should be actual cause should be there for the to make a person negligent in his activity. So let us see in this scenario, the plaintiff who is using the defendant for negligence has a liability to prove is that the defendant violation of the duty was actually cause of the damage occurred by him. There should be a violation of the duty towards the by the defendant towards the plaintiff. If that thing will be happen, then naturally that we can say the actual cause. And this is often called but for causation, which means that but for the defendant action, the plaintiff would not have incurred damages. So, but for the defendant actions, the plaintiff would not have incurred the damages. In the sense, if the defendant could not do it, then the plaintiff would have to not get any damages. I mean, he will not injured over there. For example, when a bus strikes a car, the bus driver actions are the actual cause of the accident. The reason is here cause of accident is rash and negligent driving. Cause of action is rash and negligent driving would be there. There is a cause of action. Because of that thing, it is happened. Of course, there is a, who is the right, who is the wrong, whether it's going the right side, whether it's going the wrong side, and whether he applied the brake, and how much the speed he has to go over there, whether it's the school zone, whether the village zone, whether the bumps are there, whether the speed breakers are there or not. All other things, then if they applied the brake or the brake failed, suppose if they applied the bait, how much the skidding length would be there. If the skidding length is more, naturally that bus is in a high speed. So that was the actual cause or the cause of a fact will come into the picture. Then the fifth one is the proximate cause, means very nearness of the cause. In the legal cause, which is the foreseeable also, and which is not too remote to expect that the thing is going to happen. So that is a proximate cause also an important factor when you are measuring the, when you are counting and when you are keeping a person the negligent or booking under the negligence. And a very remarkable case law is here that the Palsgraf versus Long Island Railway Company, that is the 1928 case law. Here in this case law, a man was hurrying while trying to catch a train. So he's like a passenger and he's trying to catch the train and he's carrying a packet and item with him, which is kept in the shoulder, in the arm, not shoulder, in the arm. The employees of the railway saw the man and who's attempting to board the train, and the another person who is also an employee of the railway company, the inside. So the inside man is what I say, he tried to drag him, and the outside man who is there on the platform, he tried to push him, the passenger who wants to board the train. So here an employee on the rail car attempted to pull him inside the train, while the other employee who was on the platform attempted to push him to board the train. Due to the action of these employees, the man dropped the package which is there under the arm, which had contained the fireworks. And the fireworks, when they fell down on the rails, on the sleepers, they exploded and hit the rails. When it exploded, the sleepers and the rails, the scales are there. The scales comes out from the area and hit the person who is there on the platform. So due to the explosion, the scales fell from the opposite end of the station and hit another person, Mrs. Pasgraf, and she's a lady, and who then sued the railway company. The court held that Palsgraf was not entitled to damage because the relationship between the action of the employees and the injuries caused to him were not direct enough. It is too remote to think such a thing will happen and it will explode. The scales will come out from the gap from the other direction and hit a person who is there on the another platform. So the remote chances would be there, and no prudent man could expect such a thing. So here, any prudent person who was in the position of the railway employees could not have been expected to know the package contained the fireworks and that attempting to assist them to rail car would trigger the chain events which led to the Palsgraf injuries. So overall, what I want to say is, it's too remote to think that such a thing is going to be happen over there where the person standing at the platform will be injured because of the scales, and the scales came out of from the sleepers and the rails and cause such a harm to the plaintiff. So Then there is no proximate cause would be there. That is very much clearly in the positive case law. Yes, and then the last one is consequential harm to the plaintiff. So here the proving that the defendant failed to exercise the reasonable care is not enough. It should be proved that the failure of the defendant to exercise the reasonable care resulted in a damage to the plaintiff to whom the defendant owed a duty of care. The consequential harm to the plaintiff. Yeah, that is also important. Then one of the beautiful case law is Achyutarao Haribahu Kodwa versus State of Maharashtra, where a cotton mop was left inside the body of the negligence of the doctor. A swab left into the body of the plaintiff by the doctor. The doctor was held liable because this is also known as mentioned in the Latin maxim, res ipsa laquitur. The thing speaks for itself. Leaving the mop or swab in the body itself is a negligent act. There is no necessity that the plaintiff should have to prove it. Okay. Now let us see the harms may be fall into the following classes. What if the harms are there? Number one, bodily harm. Number two, harm to the reputation. Number three, harm to property. Number four, financial loss. And then in the last fifth one is that the E one is mental harm. So these are all the types of the injuries which will cause to a person. When such damage is proved, the defendant is bound to compensate the plaintiff for the damages occurred. Now let us see that Joseph versus Dr. George Mujile, the Kerala High Court awarded the damage money to the rupees 1,60,000 against a surgeon for performing an operation on a 24 years old girl without following the proper medical procedure, not even administering the local anesthesia. So, if a proper care will not be taken by the doctor, where one should one supposed to be followed over there, at that instance, the doctor would be negligent in the activity, and hence he should be paid the compensation to the victim. And these receipts are like Peter we already covered in the earlier classes, and we have to go through over it, where it is applicable, when it is not applicable, that I clearly mention. But let us see the novus actus intervenience. Means if any new act would come emerged over there, then the break of a chain would be there, and hence the manufacturer would not be liable. For instance, you take the ginger beer case law, where manufacturer has sold the thing and the supplier supplied it, and meanwhile there is no intervention of the other person either to open the bottle or inject the bottle or insert the bottle and make intervene with the bottle opening, and such a thing would be there, we can say that there is no actus venus in actus non novus actus intervenience, and hence the manufacturer would be held liable. Suppose if there is a break of chain would be there, naturally the person who has broken the chain would be held liable. That is the maxim where you will use it. That is called, generally this may be asked in the short questions, that is novus actus intervenience. So that is the only the thing we can make it out. Now next we will see the defenses available in a suit for the negligencies. What are the defenses available for the negligence? So Ramesh ji, are you with me? If you are with me, can you read at least one defense available in the suit for the negligence which I posted on the screen? Unmute and read. Sir, నేను read చేయను, నేను వినను. Is it your answer? Of course, if the signal's weak, I could not hear your voice also clear. But at least if you hear and understand it, I think that is more than enough. But if your contribution would be there, then naturally that I feel more happy. So let us see the defenses. Number one is the contributing negligence by the plaintiff. So generally, when you say the contributing negligence, the plaintiff, suppose if you did not wear the helmet. After now, the rule is very much changed. Even the rider should have to wear the helmet. Even the pillion rider also should have to wear the helmet. If the pillion rider did not wear the helmet, the fine will be imposed by the traffic department. Traffic police is 100 rupees. Yes. In Hyderabad, I don't know what is the position in Khammam, Kottagudem, Bhadrachalam, and Varangal or Hanamakanda is concerned. Okay, let us see that with the contributing negligence would be there. At that instance, the already not fit injury also sometimes we taken as a defense, and because when he himself gave the consent at that instant, he are not supposed to claim any compensation. So the plaintiff is not entitled to recover from the defendant if it is proved that, suppose the plaintiff by the excess of the ordinary care should have avoided the consequence of the defendant negligence. Suppose if you had taken a little care would be there, he would have avoided over there, but he did not take such a care. At that instant, the consequence of the defendant's negligence. Number two, the defendant could not have avoided the consequence of the plaintiff negligence by excess of ordinary care. In that, the defendant also should have to take the ordinary care would be there toward the plaintiff. Number three, there has been as much want of reasonable care on the plaintiff's part as on the defendant's part, and the farmer cannot sue the latter for the same. So here the third point clearly shows that there has been much want of reasonable care on the plaintiff part as on the defendant's part. The farmer can sue the latter for the same. So both the due diligence should be there. For instance, if a person who is walking in a busy street without an umbrella in his hand, he should take a little care. But a person who is walking in the busy street with the umbrella, he has to take the more reasonable care. More standard of care should be taken because this umbrella may hit somebody else because it is a busy street where the traffics are more. So the burden of proving the contributed negligence rests on the defendant always. In the first instance, in the absence of such evidence, the plaintiff is not bound to prove the non-existence. So always it is when you say that the plaintiff is the contributed to the negligence, it is the duty on the part of it. I mean, it is the burden on the part of the defendant to prove it. So here let us see the one of the case law. There is the Butterfield versus Forrester case law. The defendant had put a pole across the public thoroughfare in the Derby. He put a pole across the public thoroughfare and which had no right to do. He are not supposed to keep in a public thoroughfare such a thing which is across the, it becomes a nuisance and it causes an injury to anybody, then we can file a case against him also. The plaintiff was there riding that way at 8 o'clock in the evening in the August when dusk was coming on, but the construction was still visible from the distance of the 100 yards, and he was riding violently, came against the pole and fell with the horse. It was held that the plaintiff could not claim damages as he was also negligent. And in the daytime would be there where he could see that a pole was there. At that instance, if he has not used his due care and he is coming with a violent speed, at that on the riding the horse, now because of the pole across the Derby, then he would have to contributed it, and hence the plaintiff could not claim damages as he was also negligent in that part. Of course, if he's 100 part negligent would be there, then he will not going to get anything. Suppose his negligence is only contribution is only 20%, then 80% that he is going to get it. That is why we'll see the doctrine of apportionment of damages. Yes, the negligence percentage is removed, the rest of the percentage would be awarded to the plaintiff. Let us see another example, the Sheldon versus LW Railway Company. While the plaintiff was crossing the railway line, a servant of the railway company who was in the charge of the crossing shouted a warning to him. Due to the plaintiff being the deaf, he was unable to hear the warning and was consequently injured. The court held that the amount of the contributed negligence by him. So whenever you want to cross the railway line, suppose if it unattended railway line, you should be very much careful would be there. Suppose if you are deaf and somebody is crying also, whether the train is coming from the opposite direction, if you could not hear it, that means your contribution will be there because you are not taking the due care when you are crossing the railway crossing, looking at both the sides, the left and right side, then only try to cross the railway crossing. The second difference is for the negligence act of God, vis major. The act of God means violent wind, earthquakes, volcanoes, tsunami, hurricane, cyclone, not pandemic. Pandemic is a man-made act. COVID-19 is not a God-made act. It is the act of God. It is a man-made act. But any other thing which is not under the control of the human body and human control, then we can say it is a act of God. That is example that I know. Just now I told you and I narrated you the storms, tempests, action, that is extraordinary, the extraordinary high tide and the extraordinary rainfall. They are said to be the natural calamities or natural catastrophes or major disasters, like when famous case law, Nichols versus Marshland, where the six buns were given the way and the plaintiff down catchment area of the field were undulated in the water. At that instant, the plaintiff is not going to get any compensation because such a rained it time immemorial, and these artificial lakes are washed away, and it is said to be the act of God. But another example that we made it very much clear, Kallulal versus Hemchand, it is not an act of God because in the rainy season, rain is very common. If there is any leak in the thatched house, the leak water falls on the wall, and the wall get become wet, and after sometimes the wall fell down. In the night, when some people are sleeping adjacent to the wall, the wall when collapsed, and the people, especially the children, were sleeping over there in the Kallula versus Hemchand, where they are buried alive under the debris. At that instance, we cannot say it is the act of God. It's a man-made act that is nothing but a negligent. They did not take the care of the construction of the wall in a not construction of the wall, but the leakage should be removed over there. They have not taken the care of it. Because of that thing only, the wall got wet and becomes collapsed chances, because the gravity will be diverted, center of gravity will be diverted over there, hence it is collapsed. So that is mentioned in the Kallulal versus Hemchand, but it is not there in the screen, but I have given the example. Then another is the inevitable accident. That is a very beautiful example is the Brown versus Kendall, when the two dogs are fighting over there, the person is separating them. When separating them with the stick, then the stick directly hit the another person in the eyes, and the eye was damaged. The plaintiff brought a suit against the defendant for the assault of the battery, for the eyes loss of the eye. It was held that the injury was to the plaintiff was the result of an inevitable accident. One cannot perceive they will not have any intention, but it is an accident happened that it's said to be the inevitable accident. Then Holmes versus Mathar also is another. The pair of the horses were being driven by the grooms of the defendant in the public highway. On the account of the barking of dog, the horses started running very fast. The groom made best possible effort to control them, but failed. The horses knocked down the plaintiff, who was seriously injured, and it was held at the inevitable accident. But there is no intention such a thing, because the dark bark, these horses went. Startled and went fast running and got the injury to the people, those who are on the highway. So the another is the two shooting party case, rather is the Stanley versus Powell, because one of the shooting party has fired at the PCN, but the pellet is glanced off by touching the branch of the oak, then taken the different reflexive direction and hit the another party shooting party, which is in another direction. But it was held that the accident was an inevitable accident. Nobody could perceive it and nobody could see it, and the defendant was not liable, because this is also one of the defense is available for the negligence. Then the fourth is voluntary not fit injury. As I told you, that when a person has given the consent to undergo a certain harm, at that instant that he cannot claim for the injury. For instance, that we have studied in the earlier classes, voluntary not fit injury, where a person has given the consent for the injury, at the time he could not again claim for the damages. For instance, boxing, wrestling, or any playing, the rules and regulations are followed over there. But still, in the boxing, where the very apparent eyes socket is bruised, at that instance, he is not going to get any compensation, because it is a voluntary not fit injury. Another also the example that we have seen in the earlier, that is the photographer is taking the photographs when the horse race, car race is going on over there, because the car collisions would be there. One of the car hit him and got injured. At that instance, also the photographer will not going to get any compensation, because he has taken the risk and he went over there to shoot the photographs very close, but he could take the reasonable care over there, not to reach to them very near to the arena, but he can use the zoom, and he can sit in the gallery also, and he can take the photo as if that he is taking by standing very near to the arena or the race course where the cars are running with a high speed. So these are the things which I want to make it out about the defenses for the negligence. And negligence is a very important topic, because without negligence, the tort will not exist over there. Rather, we can say the tort law is mostly based on the negligence, and because of negligence only, the tort will happen over there in the different in nature, and different name that we will name them. And sometimes we can say defamation, sometimes we can say trespass, sometimes we can say assault, sometimes we can say false imprisonment, sometimes we can say malicious prosecution, and so on and so forth. So now let us see the what is the conclusion on the part of the negligence chapter is concerned. Because still we have some time with us, that's why we can make it out. Negligence as a tort has evolved from the English law and accepted by the Indian law as substantially important tort, because Indian tort law is nothing but the replica of the English tort law. Silhouette, a replica, or shadow, taken directly from there, but using the Indian phenomena like justice and equity, good conscience, and using based on the what is it, Indian culture and usage and the customs, there is some modification made in the tort law, but the tort law is nothing but the judge-made law, and there is very few sections are there in the tort law where the tort law is codified, like the Workman Compensation Act is there, and we can Fatal Accident Act is there, and of course there is no specifically the Newspaper Act, I believe, but the Government Liability Act is no more becoming to a law, and hence we cannot say like we do have the UK federal torts claims, and the US, UK we can have the Crown Proceeding Act, and USA we do have the federal tort claims. These are the laws would be there where the state would be held liable for the activities of their employee, and when they are not employed, when they are not liable, also it will clearly given. But such a law is not there in India, even though the law commission made in the first law commission itself only to make such a law. Okay, now let us discuss the negligence of the two types. Now one is civil negligence, and then is the criminal negligence, and we can say the gross negligence and the ordinary negligence. The negligence comes because of the breach of duty toward the plaintiff, and the duty is imposed by the law, and there is a consequential damages also there, and the damage should be also proximate. These are all the conditions would be fulfilled over there. Then we can say that a person is a negligent. An important maxim regarding a negligence is for not proving that a person is negligent or not. Then one of the maxim is the res ipsa loquitur. The thing speaks for itself, because an act itself is enough that there is no necessity of the proving on the part of the plaintiff that the negligent is the defendant. So if like in an example that we made it very much clear that if a doctor has left a swab, SWAB swab, that is a what I say, a cotton drenched with the blood, that swab, because when the blood is oozing out in the operation, and this cotton will be used over there, and the blood will be sucked out, and they will operate it. The swab is left over there in the body itself. At that instance, later on, that he came to know that the swab is found there. With that, there would be a infection happened over there, but the infection that a person is died, that means a patient is died, then itself, then the plaintiff need not to prove that there is a negligence on the part of the doctor, because the act itself says leaving the swab in the body itself is the act which clearly says that the doctor is negligent. So of course, whether the doctor is forgetting there, or the other assisting staff is forgotten over there. But generally, the surgeon will do such a thing, and where the other paramedical staff would be there for the assisting him. And it is the burden on the part of the surgeon, and who is the head, who is the leader in that operation, in the operation, the particular operation, conductor of the operation, then he should take the lead of it. Generally, if anything goes wrong over there, either he left the seizure in the body, or he left the swab in the body, and later on that the patient died over there, then we can use the recepsa acquitar. But the courts, when a negligent act cannot be explained at that instant, we need not to prove it. Also, the defense in a suit for the negligence can be used by the defendant to defend himself from a suit issued by the plaintiff. So these are the things would be there where we can make it out and delete the negligence part. With this, the negligence chapter is over, and tomorrow that I will deal a new chapter which is very much useful for your examination point of view. And please inform the other people also, those who fail and are going to appear or sit for the law of tort examination, which is going to be held on 27th of September 2021, so that that will be a very much benefit to you, because I'm taking these classes to see them. They will be get benefited out of my my lectures or my knowledge, because I believe and I practice అన్ని దానముల కన్నా విద్యాదానం in English language that we can say that in all arms, the education arms at zenith. With that motive that I am taking these classes for the benefit of the legal fraternity, at least with the view also that a knowledge should not die with the person, it should be disseminated to the people and try to use it the people. That's why in Telugu also we can also say that Manava Seve Madhava Seva. That means servicing to the man or a human being is a servicing to the God. With these ambitions, with this slogan, with this manifesto that I am taking these voluntary classes, and I'm very much thankful for your patience listening and to my classes. And here you could see what I screen. Yes, sir. Participants, can you read, Ramesh? Could you read it what I posted on the screen? Unmute and read. Yes. Ramesh, could you see it? What is there I posted on the screen? Oh, I don't know whether you don't know. Unmute and read so that I could know that you are hearing me. Okay. Might be the signals weeks are there, it seems. That's why that you are not making there. Here I made a good morning only because it's at 10:54 now. The time is AM. And thanks for listening and your patience. And the Professor Dr. Mohammed Saheb Hussain. And here listening is different and hearing is different. When you hear, you don't take a reasonable care. But when the listening, you take the reasonable care to listen what a person is giving the lecture. So more care would be there in the listening and less care would be there in the hearing. That's the appropriate word is listening. And your patience, of course, patience also will count it because if a person doesn't have the patience, naturally, whatever you want to say, you cannot say in a perfect manner, number one. And if and the receiver end also, if the receiver is not a patience enough, he could not receive it, but his only thing is mind is present and sorry, body is present and mind is absent. That would be the idea would be there. So the patience is a very much important factor. Of course, a person could not keep the patience for a longer time, and is the diverted to be their mood will be diverted soon. But sometimes we have to catch it again, keep it mood. That's why that we have to make our class as a participatory class, so that the students will participate in the class. Then the class will be a lively class, and everybody get it. Merely one way is preaching like a giving the sermon lecture, like a father giving over there, the other person just listening, other listening are opening the eyes and opening the ears and just sitting over there, we don't know. Hence the bodily present as well as the mentally present should be, both the things should be there. Then only the class should be the lively class and very weak a person could enjoy it. And the person also could learn it more in the discussion, participation. When you participate it, then you learn more. And this is the Socrates way of teaching also there, where we can say there is a, we know, what is that? One H and five W's, if I may not be mistaken. Where, when, whom, who, uh, and how. These are the things would be there where we can make it out, question it. I'm sure when you get the answer, then that is a type of the method that we should have to follow it in the process of learning. And if you question it, then only that you will get the answer. When you don't question it, you don't get the answer. And where you cannot know that what you learnt is useful to you or not, and how far it is useful to you, and how far that you can take into the directly brain. So these are all the things are there where the due care is very much important, and stand of care is be made over there, and there should not be any negligence, there should not be any carelessness. If you apply this thing, you will not learn anything. So with this, I would like to stop my today's lecture, and the negligence chapter is over. Once again, that I will say that thank you very much for your patient listening, and have a good day. Then stop sharing. Then end of the meeting and end of the everything.